Hello and welcome to today's lecture on F4, that is corporate and business law. And today we will be starting off with a new part of the syllabus, which is insolvency law. Here we will be looking at companies who are in a difficult position or in a crisis. They are also known as insolvent companies. A company who is in a difficulty or crisis is also known as an insolvent company, and that company basically has two options. They have two alternatives, two choices. They can either opt for, saving the business to carry on the business using statutory methods to help them, okay, or they can stop altogether, they can wind up the business. All right, so while I'm sharing the screen with you, let's discuss a little about liquidation. Now, liquidation, or let's say liquid assets, are something that you have been studying and hearing from the very first paper of your course, okay. Liquidation basically means the dissolution of a company, the end of a company. Okay, it is also known as winding up. Liquidation means that the company will slowly sell off all its assets, okay, in order to pay off its debts. Okay, this is also known as the process of winding up. Liquidation means the dissolution of a company, also known as winding up. Okay, the assets are realized to pay off the debts, and any surplus is returned back to the members. Okay, assets are realized to pay off the debts, and any surplus is returned back to the members. Who can decide to liquidate a business? Okay, who has the authority to liquidate a business? The directors can decide to liquidate a business. The creditors can decide to do so, and of course, the members can also decide to liquidate a business. How can the directors do it? Okay, the directors are in the very best position to tell whether the company is in a difficulty or is in a good position. All right, so directors, of course, can order a liquidation. The creditors can also do so, and the members can also do so. Of course, for liquidation, there are certain methods. There's compulsory liquidation, there's members voluntary liquidation, and there is creditors voluntary liquidation. Now, first two happen when the company is insolvent, okay, when the company is in a difficulty or crisis. And the third one, the creditors voluntary liquidation, happens when the company is in not a crisis. Okay, when the company is not in a crisis, means it is a solvent company. Now, once the company decides that it has to liquidate, okay, it has to wind up, the company goes under the control of liquidator, okay, a person who is a qualified and experienced insolvency practitioner. All right, once the company decides that it is ready to liquidate, the company goes under the control of a liquidator who must be a qualified and experienced insolvency practitioner. And once the insolvency procedure starts, once the liquidation procedure starts, the company cannot trade anymore. Okay, it cannot carry on its business anymore. The director's power stops or ceases, and all the documents must state that the company is in liquidation. All right. So, what is liquidation? It simply means the dissolution of a company, the end of a company, also known as winding up. What happens in liquidation is that the assets are realized, the assets are sold off in order to pay off the debts, and any surplus, okay, after paying off the debts, if there is any amount left, it is returned back to the members in the order of their or the amount that they have contributed in. Who decides that the company should liquidate? The directors can do so, the creditors can, and of course, the members have the power to do so. There are certain methods of liquidation. There's compulsory liquidation, there's members voluntary liquidation. Both of these happen when the company is insolvent. Okay. Now there's creditors voluntary liquidation as well, and this happens when the company is solvent. Okay. And once the company decides that it is going to liquidate, the company goes under the control of a liquidator. Who is a liquidator? A liquidator is a qualified and experienced insolvency practitioner. And once the insolvency procedure starts, the company cannot trade anymore and the power ceases, and all documents must state that the company is in liquidation. All right. Moving on to the very first method of liquidation, which is voluntary liquidation, which can be done by the members and the creditors. A winding up is voluntary. Okay, a winding up is voluntary, where the decision to wind up is taken up by the company's members. Although if the company is insolvent, the creditors will be involved in the proceedings. The main difference between a members and creditors voluntary liquidation, okay, is that the appointment of a liquidator. Of course, voluntary liquidations are of two types, members and creditors, and the very main difference between them is the appointment of a liquidator. In case the members decide to liquidate voluntarily, then the members will be the ones who will appoint a liquidator. Okay, and if the creditors decide to do that voluntarily, they will be the ones who will be, able to, they will nominate a person who will be approval. Once that person is approved, that person will be uh, given the authority of a liquidator. Next difference is the approval of liquidators actions. Okay, in a members voluntary liquidation, the general meeting of members will approve the liquidators actions, whereas in a creditors voluntary liquidation, the liquidation committee that has been set up will approve the liquidators actions. And last of all, there is no liquidation committee if the voluntary liquidation is from the side of the members. Okay, and if it is from the creditors, then of course there will be a liquidation committee that will be made up of up to 5 representatives from the side of the creditors. In both the cases, whether it was a members voluntary liquidation or whether it was a creditors voluntary liquidation, both the cases, the courts have the power to appoint a liquidator or to remove or appoint another. Let's talk about in detail of members voluntary liquidation. Okay, now in this liquid type of liquidation, in members voluntary liquidation, the directors must make a declaration of solvency. Okay, the director is supposed to make a declaration of solvency. What is a declaration of solvency? Okay, a declaration of solvency, okay, means that the company, a voluntary winding up is a member's voluntary winding up only if the directors make and deliver to the registered declaration of insolvency. Okay, it is a criminal offense. It is a crime to make a declaration without reasonable grounds. Okay, a special resolution has to be passed in order to wind up, but in some cases, ordinary resolutions can also be passed if specified in the articles. The creditors play no part with the assumptions that their debts will be paid in full. When the liquidation is complete, the liquidator calls a final meeting and presents the final accounts. And last of all, after holding the final meeting, the liquidator sends a copy of their accounts to the registrar, who dissolves the company after 3 months by removing their name from the register. Okay, so these are the points that will tell you how a member's voluntary liquidation will take place. First of all, there will be a declaration of solvency made from the directors. This is a statement, okay, that the company cannot, carry on its business anymore. And of course, it is a criminal offense if they make this declaration without reasonable grounds. And a special resolution has to be passed if the company wants to end its business or wind up. But in some cases, ordinary resolutions can also be passed if it is written in the articles of association that were, made that were written when the company started off, when the company was incorporated. And in a member's voluntary liquidation, the creditors will play no part, okay, with the assumption that is given here is that the creditors, of course, will get what is theirs, they will get their part. So they will have no, they will have no part to play in that. They will get whatever they require. All right. Next is that when the liquidation is complete, when all the process they are, when the members voluntary liquidation is complete, the liquidator calls a final meeting and presents the final accounts. And after holding the final meeting, the liquidator sends a copy of their accounts to the registrar, who dissolves the company after 3 months by removing their name from the register. What's creditors voluntary liquidation? In this particular type of liquidation, there is no statement or no declaration of solvency from anywhere. And in order to start off a creditor's voluntary liquidation, a general meeting is called and a special resolution is passed. A liquidator is nominated and a liquidation committee is established. Okay. In a creditor's voluntary liquidation, there is no declaration of solvency from anyone. And in order to start it off, a meeting is called and a special resolution is passed. A liquidator is nominated and a liquidation committee is established. Center binding. Let's talk a little about center binding. What is center binding? In the past, the members, nominee for liquidator has been exploited for the purpose known as center binding. What is center binding? We will study that through re-center bind limited case. What was the case? The facts of this case were that the directors convened a general meeting without making a statutory declaration of solvency, but failed to call a creditors meeting for the same or the next day. The penalty for this was merely a small default fine. The liquidator chosen by the members had disposed of the assets before the creditors could appoint a liquidator. The creditors liquidator challenged the sale of the assets at a low price as invalid. What was the decision that was given? The first liquidator had been in office when he made the sale, and so it was a valid exercise of the normal power of sale. In certain binding exercises or in these transactions, the assets are sold by an obliging liquidator to a new company formed by the members of the insolvent company. This is what happens in the principle of center binding. Okay, in these type of transactions, what happens is that the assets are sold by an obliging liquidator, and a liquidator who is appointed to a new company formed by the members of the insolvent company. Let's talk a little about compulsory liquidation. Compulsory liquidation is done when the company is solvent. Okay. The Insolvency Act specifies 7 statutory reasons for the compulsory liquidation. Of course, there's an Insolvency Act, and there are seven, statutory reasons for which compulsory liquidation of a solvent company can be ordered. But our syllabus, the syllabus that we are following, focuses only on 2 reasons. Okay, when the company is unable to pay its debts and it is just and equitable to wind up the company. Okay, the 2 reasons that we focus on are that the company is unable to pay its debts. Of course, the company has to be liquidated now, and it would be just and equitable to wind up the company. The government also has the option to file a petition for the compulsory winding up of the company if the company has not obtained a trading certificate within 1 year of incorporation. Okay, the government can order a company, or they can file a petition with the court to end up a company or wind up a company if they have not obtained a trading certificate. Remember, in order to start business, in order to be called an incorporated business or an incorporation, you had to obtain a trading certificate. And if the company has not done so within 1 year of incorporation, they can be asked for a compulsory liquidation. And secondly, if it is in public interest to do so. An administrator of the company can also apply on behalf of the company through an administration process. This is all about compulsory liquidation. Now, moving on to order of payments on liquidation, let's say liquidation has happened. Now, in what order will the people pay? Will the members paid, or debts of the company will be paid in what order? First of all, the company's costs will be paid off. These will be prioritized at first. These include the cost of selling the assets, the liquidator's remuneration, and all costs incidental to the liquidation procedure. After that come the preferential debts. What comes under the heading of preferential debts is employees' wages, okay, accrued holiday pay, and contributions to an occupational pension fund. These are preferential debts. After these have been paid off, the next thing that will be paid off is the debts secured by floating charges. Okay. After that, debts which are to unsecured ordinary creditors. Then there are deferred debts. What are deferred debts? These include dividends declared but not paid and interest accrued on debts since liquidation. These are deferred debts. And at the end, when all of these are done, if there is an amount that remains, then that surplus amount is paid off to the members of the company. All right. Any surplus, okay, which is highly unlikely, is distributed to members according to their rights under the articles or the terms of issue of their shares. All right. Now, there are certain differences between uh, voluntary liquidation and compulsory liquidation. What those are, there's the difference of control. Okay. Under a member's voluntary liquidation, the members control the liquidation process. Under a creditor's voluntary liquidation, the creditors control the process. The court controls the process under a compulsory liquidation. There's the difference of control. Okay. Whoever is involved in the liquidation, that person controls it. If it's a members voluntary liquidation, the members will control it. If it is a creditors voluntary liquidation, the creditors will control the process. And if it's a compulsory liquidation, then the courts will control it. Okay. Then there's this difference of timing. A voluntary winding up commences on the day when the resolution to wind up is passed. It is not retrospective. It does not have a backflash effect. A compulsory winding up, once agreed to by the court, commences on the day the petition was presented. What's the difference of timing in a voluntary liquidation? Voluntary liquidation will start when the resolution to wind up is passed. Okay, that can be commence on the day when the day it's passed, and compulsory liquidation will start off the same day when the petition was filed, or when the petition was presented. There's this difference of liquidator. The official receiver plays no role in a voluntary winding up, whereas the members or creditors select and appoint the liquidator, and they are not an officer of the court. Then there are legal proceedings. In a voluntary winding up, there is no automatic stay of legal proceedings against the company, nor are previous dispositions or seizures of its assets void. However, the liquidator has a general right to apply to the court to make any order which the court can make in a compulsory liquidation. They would do so, for instance, to prevent any creditor obtaining an unfair advantage over the other creditors. Management and staff in any liquidation, whether it was a voluntary liquidation or whether it was a compulsory liquidation, the liquidator replaces the directors in the management of the company unless the liquidator decides to retain them. However, the employees are not automatically dismissed by commencement of a voluntary liquidation. Insolvent liquidation may amount to repudiation of their employment contracts. All right. So these are some of the differences between a voluntary liquidation and compulsory liquidation. Moving on to administration. Let's say the company does not want to stop its business, it wants to save itself. Then it will start off with the process of administration. Saving a company. Administration simply means saving a company. An administrator is appointed to rescue a company as a going concern. Okay, when the members of the company want to save it, when the directors of the company want to save it, they do not want to wind up their business, they appoint an administrator whose sole purpose is to rescue the company as a going concern. Okay. Now, this process puts an insolvency practitioner in place to control the company. Now, when the company decides to do administration, the insolvency practitioner will be put in place to control the company. Okay. Now, administration can be initiated, which means that administration can be started off without a court order. Okay, administration can be initiated or started off without a court order, and it can be started with a court order. If the administration is started or initiated without a court order, floating charge holders, directors, and company can do so. Okay, floating charge year holders have the right to appoint an administrator without reference to the court, even if there is no actual or impending insolvency. Okay, and if it is done so with a court order, then who can do it? Then who can, you put in place the insolvency practitioner, the company, the directors, the creditors, and another court order. The administrator has certain fiduciary duties as well as some legal duties. Okay, if you are an administrator, if you have been put in place to save a company, then of course there is a fiduciary duty of saving the company. Okay, and of course there are also some statutory or legal duties which you have to follow. One of them is to send notice of appointment to the company. Okay, send notice of appointment to the company. You should publish the notice. Okay, and send the notice of the to the company creditors. Okay, the administration notice is what we are talking about here, and this notice should be sent within 7 days to the registrar. There should be a statement of affairs that should be made. Okay, then there you should consider the statement of affairs and manage the affairs of the company. The administrator must either state a rescue plan or state that the company cannot be rescued. This is stated in the statement of affairs. Okay. The administrator should state that the company can either be saved or it cannot be saved. In both of the situations, the administrator has to state it in the statement of affairs. Okay. The proposal must be sent to all members and creditors. This proposal, okay, if the company is decided to be saved. The administrator must call a meeting of creditors within 10 weeks of their appointment to approve the proposals. The administrator will take up the powers of the directors, which means that he will manage the company now, just as the directors used to do so. Okay. Now, the process of administration can last up to 12 months. The time limit for the process of administration is 12 months or 1 year. And the period of administration can end when the administration has been successful. When can the period of administration end? It can end when the administration has been successful, or the time limit, that is the 12 months that have been passed. The administrator or creditor applies to end the process. An improper motive of applicant is discovered. If an improper motive of applicant is discovered, then also administration has to end right away. Now, the main advantages of administration are to the company, its member, and its creditors. Okay, so this was all about your insolvency law, types of liquidations, methods of liquidations, and if the company does not decide to liquidate, then what it can do, it can take up administration. All right. So that's all for today. Thank you very much.